In today's video, we will be discussing a recent ruling by U.S. District Judge Tanya Chupkan. The ruling has allowed the spouses of H-1B visa holders to work in the USA. This decision has been a cause of celebration for many, especially for families who were facing financial difficulties due to the inability of H-1B spouses to work. Background: the H-1B visa program allows skilled foreign workers to travel to the USA and work for American businesses. However, until recently, H-1B spouses were not permitted to work, which frequently put a heavy financial burden on families. The ruling: U.S. District Judge Tanya Chupkan dismissed a case brought by Safe Jobs USA, which had asked the court to overturn an Obama-era regulation that granted employment authorization cards to spouses of certain types of H-1B visa holders. In the course of the proceedings, Judge Chupkan announced that spouses of H-1B visa holders will now be able to work in the USA. Argument of Safe Jobs USA. The main argument raised by Safe Jobs USA was that Congress never gave the Department of Homeland Security the authority to permit foreign people on H-4 visas to work while they are in the country. However, Judge Chupkan noted that this argument is directly contradicted by the Immigration and Nationality Acts, decades of executive branch practice, and both explicit and implicit congressional approval of that practice. Congress approval. According to the judge's ruling, Congress explicitly and deliberately gave the American government the authority to approve employment as a legitimate precondition for an H-4 spouse's immigration to the country. The federal government's historic and transparent duty for approving employment for comparable visa classes demonstrates that Congress has approved the use of that authority by the federal government. The Department of Homeland Security. The Department of Homeland Security and its predecessors have approved employment not only for students but also for their spouses and dependents. The judge rejected the complaint brought by Safe Jobs USA, writing that the Department of Homeland Security has long granted work permits to wives of foreign government officials and spouses of workers or officers of international organizations. Local figure support. A well-known local figure and supporter of immigrant rights has praised the court's decision to permit H-1B wives to support their families through employment. Conclusion. In conclusion, the recent ruling by U.S. District Judge Tanya Chupkan has allowed spouses of H-1B visa holders to work in the USA. This decision has been celebrated by many, especially for families who are facing financial difficulties. It is a significant step towards improving the lives of H-1B spouses and their families.